Lord.
Yes, Mr. Bennett.
Well, Lord, over the adjournment, we've handed up 2 sheets of paper which are statutory provisions which I've suggested should go in tab 1 of the authorities one. But can I explain what they are in a moment? Because I... Before turning to that, just to conclude my argument on the issue I was raising before lunch, we have referred in our skeleton argument, and I'm not going to go now to these authorities, but we've referred to authorities for the proposition that even on a Section 204 appeal, court hearing such an appeal does not have a jurisdiction to make his or her own findings of fact. Again, that might not be regarded as entirely
it's an appeal only on a point of law.
Yes, it is. But the point has plainly risen enough times that the senior courts have been troubled with it. May I simply give you the references without taking your lordship to the cases? Yes. And they are in the authorities bundle at tab 2, Cadona at 37 to 39.
With paragraphs 37.
Paragraphs 37 to 39.
Thank you.
Kruja, K-R-U-J-A, at tab 3, at paragraph 22. And at tab 9, the head note of Bub, and paragraphs 19 to 21. As I say, I'm not going to take the court to those cases, but my submission, our submission, that if on a statutory appeal the court has no power to do that, then the same must also be the case in judicial review. As I say, that may not be a startling opposition from my lord.
No, I think I've given many judgments saying that in judicial review it's not the function of the court to make its own findings of fact.
My lord, can I turn then finally to the 2 construction points? And can I start with...
So which grounds does this go to?
So the first point I'm going to raise now goes to ground 2, which is the question of whether, as a matter of law, matter of construction, Section 1936D applies in this case. And the judge's ruling that as a matter of construction it does not. My lord, there might be...
this is the point that it only applies to property which is being made available and is suitable.
Yes. My lord, it is a fairly short point of statutory construction. In order to make it good, we have referred in our skeleton argument to a number of points on pages A31 and A32 of the core bundle, particularly between paragraphs 42 and 50. If I could just give the court the highlights in the light of the time constraints we're under. That Section 193, as I have already submitted, provides that a duty to secure accommodation continues until it ceases by virtue of any of the following provisions of this section. Now, we respectfully submit that where Parliament regarded the provision of accommodation that was suitable as a component of one of the provisions by virtue of which a duty ceases, it has said so. And we see that in Section 193 subsection 5, which under little a, makes specific reference to the possibility of the requirement to inform the person of the ability to request a review of the suitability of an offer, and that the authority must be satisfied that the offer was suitable as a precondition to the duty ceasing. And we can also see in subsection 7 that where what is referred to as a final offer, the authority must have informed the person of their right to request a review of the suitability of the accommodation.
These are both cases where an offer is made and it's refused by the applicant.
Yeah. But in 5,
on the basis of unsuitability.
Yeah. Well, it may or may not be refused on the basis of unsuitability.
But if it is suitable,
the authority has to satisfy that it is suitable before they can discharge the duty. And one of the documents we handed up was the original form of section 193, which is at page 16b now of tab 1 of the authorities bundle, because I just thought it might be helpful to see that even when the Act was first enacted, although the wording of the sections, of the subsections was different, the proposition in this respect was the same, because by subsection 5, the duty ceased if the authority had informed of possible consequences of refusal, that they were satisfied that it was suitable for them. And in section 193(7)(b), in relation to a Part 6 offer of accommodation, which is now called a final offer, in B, the authority are satisfied that the accommodation was suitable for it, and it was reasonable for them to accept it. At that time, section 1933 was in different terms, and the duty only arose for a period of 2 years. So there was no equivalent provision saying that the duty continues until it comes to an end by virtue of one of the provisions of the section, because it automatically came to an end and was replaced by a power after 2 years. But that provision was repealed from memory in 2002, and the current requirement that a duty must continue until it comes to an end by virtue of one of the provisions of the section was introduced to replace it. Now, what we say about subsection 6 is that it creates a set of circumstances in which accommodation hasn't been refused, but the duty nonetheless comes to an end. One of which is where the person ceases to be eligible for assistance. One of which is where the person becomes homeless intentionally from the accommodation. One of which is where he accepts an offer of Part 6, long-term accommodation. And then we come to D, which is the paragraph provided by the local authority in this case. We've introduced into the bundle, as the other sheet of paper that I handed up at lunchtime, at page 16A, because we thought it might be useful for the court to see this, the definition of homeless intentionally, which arises under subsection 6B. And the definition is contained in section 1911. person becomes homeless intentionally if he deliberately does or fails to do anything in consequence, he ceases to occupy accommodation which is available for his occupation and which it would have been reasonable for him to continue to. So deliberately leaving accommodation would be an act which would fall within subsection 1. But that provision is qualified by the fact that in order to become intentionally homeless by voluntarily leaving the accommodation, it has to have been accommodation which was available for his occupation and which it would have been reasonable for him to continue to occupy. Subsection D, on the other hand, in my submission, simply appears to be a sweeping up of other circumstances in which somebody gives up accommodation made available for them. In particular, they otherwise voluntarily cease to occupy. So in circumstances that don't amount to intentional homelessness or acceptance of another offer.
Well, isn't just otherwise in the sense of other than in the preceding paragraphs
Yes.
of that section?
That's what
Yeah.
that's what it would appear to be. Otherwise, voluntarily is also quite important. Ceases to occupy as his only or principal home the accommodation made available. So it wouldn't apply if somebody simply went on holiday, for example, or vacated temporarily for a reason that did not amount to giving up the property as your only or principal home. But the only qualification other than that, well, it's not really a qualification, the only requirement is that it was the accommodation made available for his occupation. One of the points that we have emphasised in our argument, in our written argument, is that, as the court will be well aware, there are quite often, as in the present case, quite significant disputes about whether or not accommodation is suitable or not. And as the judge below recognised, and as the Supreme Court held in the Birmingham and Alley case, which is at tab 7 of my Lord's bundle of authority, it's an established proposition of law that accommodation can be suitable at some times and not at other times. It might be, for example, that it's suitable for a short period pending the availability of a longer term accommodation that would be available that would be suitable for a longer period. It might be that a person who's overcrowded in accommodation changes the composition of their household so that they're no longer overcrowded, which might mean that the accommodation was unsuitable at one point but subsequently became suitable. We say respectfully that Judge Rawlins was correct to say, as he did, that accommodation which was unsuitable could subsequently become suitable. Indeed, the whole factual basis of this case was that once the adaptation works were completed, Holden Close would become suitable. The question was, had it yet? And that was where the dispute was focused at the point of this case coming before the court below. So, in circumstances where there can be quite a lot of uncertainty at any particular point in time as to whether accommodation is suitable or unsuitable, it's our respectful submission that Parliament, bearing in mind the structure and wording of other subsections of this section, has deliberately not introduced the same qualification into subsection 6D that it introduced into subsection 5 and subsection 7, namely that the accommodation must be suitable at the point at which the person ceases to occupy. We respectfully submit that this is a general clause bringing to an end a duty where the person has left, where the person has gone away from the accommodation that's made available. It doesn't matter whether, as a matter of technical homelessness law, the local authority was entitled to conclude, or might have been entitled to conclude, that the accommodation was suitable or unsuitable. This is about people who simply voluntarily, and that's why I say that word is important, voluntarily give up accommodation and go away. One of the hypothetical examples we give in our skeleton is a person who decides that they're going to relocate to Manchester or another country. But nonetheless, because the accommodation might happen to have been unsuitable for some reason at the time they left, the duty not only continues, but cannot be brought to an end by the authority, because there is no other provision of section 193 that would bring it to it.
Subsections 5 and 7, as you said, are dealing with an offer.
Yeah.
And it's an offer which isn't taken up.
Yeah.
So the offeree doesn't go into occupation. So it's in that context that suitability is used as a criterion. And one wouldn't say that that accommodation, in fact those provisions don't use the words made available.
No.
But those words made available do appear in subsection 6D. They don't appear in the intentionally homeless provision 191 subsection 1. That uses the word available.
Yes.
What is connoted by made available?
It's the accommodation that has been made available in the sense that the duty under section 193 2 is not to provide accommodation, it's simply to secure that it becomes available.
So it reflects accommodation provided by a local housing authority in accordance with its duty.
Well, accommodation that is secured rather than...
Well, I meant to embrace that. You're absolutely right. They may provide it directly, they may go to a third party and
yes,
so on.
Exactly.
But it's in furtherance of compliance with the duty.
It's in accordance with the requirements of... it's in accordance with the duty that has arisen.
In subsection 6, paragraph B also uses the phrase accommodation made available for his occupation. So is it your submission that in paragraph B it doesn't matter that the accommodation made available is unsuitable? The fact is it has been made available.
No, my lord. My submission is that the distinction between B and D is quite important, because to have been homeless intentionally, it has to have been accommodation that was reasonable for you to continue to occupy. And if it wasn't suitable, then it would seem that there would be a strong argument that it wasn't reasonable to continue to occupy. So what we're saying is there would be no real difference between B and D if suitability was also imported into D. Because if you leave suitable accommodation that has been made available to you in performance of the duty as your only or principal home voluntarily, it's difficult to see why that would not, if suitability was an element of that, also fall within B. What different scenario D was intended to meet? And it's our case that D is deliberately widely drafted by Parliament.
I'm wondering though, if accommodation is not suitable for somebody, and suitable in the sense of not providing for their basic needs, and in what sense have they voluntarily ceased to occupy? Surely, to use more colloquial language, you say that they've been forced out because they haven't got, for instance, toilet facilities they can use. Then have they left voluntarily?
Well, but I would entirely concur, respectfully accept my Lord's point. If somebody has not been able to reside there, if somebody has been forced out because because the circumstances were so appalling, then I would accept they hadn't left voluntarily.
But how can you say, surely that's the point, isn't it? If it's not suitable for you, then how can you say that you left voluntarily? Because this is all about providing suitable accommodation.
Well, I might leave accommodation that I say isn't suitable for me because my sister wins the lottery, buys a big house and says, come and live with me. Now that wouldn't have anything to do necessarily with the quality of the accommodation. It would simply be an unrelated factor that caused me to go. I might decide to emigrate. I might, for example, used by Melanie this morning, I might meet a person and decide that I want to be their partner. And we might decide we're going to go and find our own place somewhere. There are all sorts of reasons why people might leave accommodation voluntarily.
I can see that if you provided suitable accommodation and somebody leaves for one of those reasons, they may have left voluntarily, then it's no problem. But if the accommodation isn't suitable in the first place and they leave, then it seems to me that that analysis, that state, is that they have not left voluntarily, but it is because it's not suitable.
My Lord, respectfully, my submission would be that that is an issue that would be fact sensitive to the individual case. I might be in accommodation which is not suitable, not because there's anything wrong with it in terms of its physical facilities or condition, but because I say it's too far away from my children's school.
But the other thing is, has accommodation been made available for occupation if it's not suitable?
Well, we say yes, it has been.
If it's not suitable for you to live there, how can it be made available for you to occupy?
Because we say that the accommodation that has been made available, again, is a matter of fact. If you're given an offer of accommodation and you are made that offer in accordance with the section, then that's the accommodation that's been made available. Now,
well, it may have been made available, but has it been made available for your occupation? If it's not suitable for you to occupy?
Well, my Lord, I think it's, if I may say so, it's important not to assume that suitability is necessarily a question of the condition of the property or the facilities available. There are a wide range of factors that might affect the question of suitability, such as location, cost, but also a lot of applicants may regard certain factors as relevant to the suitability of it that the local authority would not recognise as relevant, and therefore that would have to be a matter that was challenged by review and appeal to the county court. While all of that is going on, it may be entirely unclear whether or not the authority has provided or secured or made available accommodation.
But that's inherent in the system, even on your analysis.
I'm sorry,
that's inherent in the system, even on your analysis.
It's inherent in the system, but it's not inherent in the duty coming to an end on my analysis. As I say, that Parliament wasn't inviting the court or the parties to get involved in the difficult questions of suitability when looking at this subsection. My submission is, this is a widely drafted subsection. If accommodation is made available and you voluntarily leave it, and I accept that wouldn't include being forced out of it, or it being so appalling that you couldn't bear it, and you voluntarily not only leave it, but you voluntarily leave it as your only or principal home. In other words, you're not just going to... So to give an example, if I said to the local authority, look, this place is so bad, I'm booking myself into a hotel till you've sorted it out. That wouldn't be within subsection 6D, because that wouldn't be giving it up as my only or principal home. And it arguably wouldn't be voluntary either. But if I say...
So in that case, the duty continues.
So in that case, the duty would continue.
We're slightly struggling to see what we're really arguing about here.
Well, what we're arguing, if I can just put the facts of this case as the authority has seen them. The respondent in this case goes and takes a license in supported accommodation by herself and says to the social worker and the adult social care officers from the local authority, I don't want to live with my brother anymore. And she goes off and finds herself accommodation and asks the local...
This is disputed. So.
I know, I'm just saying, as the authority, I'm not saying this is undisputed. I'm saying this was the case the authority put to the judge below. So she goes off, she finds herself accommodation, and she says to the Housing Benefit Department, please transfer my housing benefit to this new place that I've found, and my new landlord. And she's gone. That's it. She's gone. She's left her brother in the accommodation. In fact, he ended up moving. But she goes and finds someone new for herself. In circumstances like that, we say, well, look, the household has changed. She doesn't want to live with him anymore. The works are ongoing. But she's decided to go off and live by herself. In those circumstances, the authority should not continue to be under a duty to provide her with further accommodation or secure further accommodation pursuant to that homelessness application. Obviously doesn't stop her making a new application, but not pursuant to that application.
Well, in that situation, the accommodation might have been suitable.
Might have.
But this doesn't really help to deal with the point of construction as to whether suitability either is or isn't a relevant consideration.
No, my lord, I may have got slightly sidetracked in trying to...
Which is what this ground is about.
Yes, this is what it's about.
No, I'm very conscious, A, of the time, and B, that clock is actually slow. So you've got 2 minutes.
My lord, yes. My lord, I think in that time, what I need to do is take you to the final argument on construction in relation to the letter,
Right.
which is my ground 4.
Yep.
And I need to simply put forward my propositions about it. It's page 18. Sorry. B18. And I'm not going to take more than the couple of minutes I have. It's a short letter, dated the 4th of June. The meat of the letter is in the long paragraph, third paragraph, but it sets out in the first paragraph that the issues have been raised regarding suitability. And the point that is made is that the ground floor toilet is too narrow for wheelchair access and the stair lift is unsuitable. We have been advised by our client today that on the recommendation of the OT, a commode has already been provided and a bed has been placed in the living room, while our client has made an urgent referral for a through lift to be located in the reception room to enable your client to have access to all facilities. We have been advised by the temporary accommodation manager today that the urgent request for such works have already been submitted with an estimated completion time of 4 weeks. We have also been advised that our client has made urgent inquiries with the OT regarding a care plan to assist with Mr. Fowell's washing and hygiene during this period and has been provided with the details of the rest. We will revert to you as a matter of urgency as soon as additional information is confirmed. Now, the point we make about this letter is that on any analysis we respectfully say that is not a conclusion that the accommodation was unsuitable. It is setting out that works are being done in order to render the accommodation and all the facilities accessible, and that in the meantime a number of measures have been and are in the course of being taken in order to mitigate the immediate problems caused by the toilet being too narrow and the stair lift being unsuitable. If the authority was saying, we accept that this is unsuitable, it would have said so. But if it was saying that, it makes no sense for it also to be saying, we're doing all these other things in order to render the accommodation
Why were they doing it and doing it so urgent if it's already suitable?
Because the accommodation was not being said to be... so accommodation that is not suitable for a long time might be suitable for a short time. Right? So you might need to do more.
You wouldn't offer temporary accommodation if that was the case.
Well,
it was the temporary accommodation which was going to be a short-term solution whilst the adaptations were carried out. In the meantime...
Well, this was the...
I mean, they couldn't get to the first floor.
This was the temporary accommodation.
But I thought this was in parallel with use of hotel accommodation.
Well, a hotel was then offered.
Yeah.
But it is quite common, although this may not be generally accepted, but it's quite common for local authorities to say, look, this is what we're doing, but if you don't want that, you know, we'll try and do something else. And that doesn't mean that they're concluding that this is not suitable. It just means that if you'd prefer to go into a hotel...
I think we do have this point, and I am very conscious that Mr. Nabby really needs to get onto his
I do accept that, my lord. All I'm saying, this was and was necessarily temporary accommodation. It can be suitable pending the completion of work by reference to the mitigation measures that are taking place. This letter, whatever its fault may be, whatever the authority's fault may be, this letter was not...
I think we do understand. Your submission is the judge misconstrued this letter. We understand that. Is there anything else you need to say?
My lord, I think at this stage I'll reserve anything else.
Is there anything else, my lords? Thank you very much.
I'm great.
Yes, Mr. Nabby.
My lords, before I go into my submissions, just an answer to a question that was raised this morning about whether any indication was given as to how long the works would take or when they would be completed. May I refer your lordships to D76 in the supplementary bundle, electronic page numbering 315, which is a letter of the 24th of September, shortly before the hearing, written by my solicitors, and in particular the penultimate paragraph.
So what's the point you're making?
The point we're making is one of the questions that was raised this morning was there any indication about how long the works were going to take or when they were going to be completed? And the point I'm making is that my solicitors are writing to Birmingham saying we've repeatedly asked for a timetable as to when the work's going to be completed, and we've had no reply.
That was E76.
D76.
D76.
My apologies.
No, my fault.
Right.
My lords, in our submission, this appeal raises three issues. Issue one, is it a precondition of section 1936D that the accommodation which has been vacated is suitable accommodation, must be suitable accommodation? And our short answer to that is yes, it is a precondition. Issue two, did the judge err in his approach to the standard of review to be applied in judicial review proceedings? We submit he didn't if one looks at the judgment in totality, in what he's actually doing and being asked to decide. But even if he did, he was entitled to come to the same conclusions on a judicial review approach. And then issue 3, was the judge correct to decide, to consider the issue of cessation of duty and or the suitability of the offer of accommodation made by the appellant? And we submit that he was. And because accommodation has to be suitable, we say on our analysis, once he'd reached a decision on section 193.16, he didn't have to go on to consider suitability.
Well, he didn't?
Because we say that the discharge of duty decision relies on 193.16, which we say must be suitable before it bites. Once he'd found that it had to be suitable, contrary to what was being submitted towards, then that was sufficient. But if he had to go on to consider suitability, he was entitled to do so in the exceptional circumstances of this case.
Now, in that list of issues, what you haven't mentioned is whether the judge should have been embarking on any of this, given that there's an alternative remedy.
Well, yes, well, that's issue 3. Was he right to consider the issue of cessation of
I see.
and or the suitability of the
Okay.
That's where judicial review comes in.
That's your summary of that.
That's right.
I see.
And, well, look, before I'm conscious of the time, before I explore issues just a little bit of depth, I may just make some bold sort of headline points as to what a summary of what our case is. We say firstly that the main housing duty can only be performed by a housing authority making available suitable accommodation. And the word only appears in section 206, to which you are not taken by my learned friend. Secondly, if the duty is not being lawfully performed, as we say, because suitable accommodation has not been made available, then the authority can't rely on 193.16 to assert cessation of duty, because to hold otherwise would be contrary to this homelessness welfare scheme. If an authority can provide unsuitable accommodation, which a person needs, for whatever reason, and then say that the duty.
Well, there may be two, arguably, there may be 2 points wrapped up in that submission. One, the local authority could rely on its own default.
That is a point that we made. That's we refer to Robinson and Harrison.
I see.
Well,
And the second point you make is a more general one about statutory construction.
That's right.
That this is a benign piece of social legislation which should be construed so as to give full effect to its purpose.
Yes, my Lord, and when I deal with that point, just a little more detail. Those are exactly the 2 points.
I see.
Because the authority shouldn't be allowed to take advantage of it. And then on the material before him, we say, the judge was entitled on a public law basis, and I'll make good this submission, to find that, firstly, that the authority had accepted that 7 Holden Close was not suitable. It had itself accepted. Alternatively, the judge was entitled to find that no authority acting rationally could have decided that 7 Holden Close was suitable at the point it asserted discharge of duty. And thirdly, that the defendant had withdrawn the offer of the Ladbroke Hotel. My Lord, our case is you don't need to consider the Ladbroke Hotel because it's not referred to in the discharge of duty letter. And insofar it's relevant, it's only relevant to did the local authority take all reasonable steps, the Imam test, and the appellant has been refused permission to appeal on that ground. And then just very shortly on the third issue, we say that the reason the judge was entitled to consider the discharge of duty letter, despite the availability of the other remedy, was because of his construction of section 19316. His finding, which we say he was lawfully entitled to make, that 7 Holden Close was not suitable. And given that he'd made those 2 findings which he was entitled to make, he was then entitled to consider whether, as a matter of law, the appellant was in breach of the main housing duty. Further, we say that the circumstances of this case amounted to sufficiently exceptional circumstances. Going then firstly, and I take section 19360 point first, and my lord, if I may just, in the authorities bundle, refer you to section 206, which is at page 26. And for our purposes, it's section 206(1). And the important word is, well, there are quite a few important words in this subsection. But first of all, only in the following ways. So it's not a freestanding duty. And the mechanism for performing the duty, discharging the duty, is by securing that suitable accommodation provided by them is available. Here we have the rubric again of is available. Or by securing that he obtains suitable accommodation from some other person, or by giving him such advice and assistance as will secure that suitable accommodation is available from some other person. And my lord, you will have seen that 206 isn't just referring to section 193, but is also referring to housing functions generally. i.e. any accommodation that is provided under Part 7 in the performance of the Part 7 function has to be suitable. On my learned friend's submission, or in writing, that if suitable isn't contained in the sentence in 193, then it doesn't have to be suitable, is simply wrong, and I can refer to authority to make that submission good. First of all, my lords, if I could refer to Griffiths and St. Helens, which is tab 4 of the bundle of authorities. So this is a case about whether accommodation was suitable or not, and whether the homelessness duty had come to an end. There are 3 paragraphs I would refer your lordships to. First of all, paragraph 22, which is at page 63. Which talks about the section 1935 duty, which is the duty to provide temporary accommodation, which this was. And over the page, it says, Mr. Luber accepts that the local housing authority can perform their section 193 duty by offering suitable temporary accommodation. If it subsequently ceases to be available, and if other relevant facts have not changed, the duty revives. He's understandably coy about whether the duty was performed or ceased or was discharged while the suitable temporary accommodation was available, or whether it was dormant. And such questions should be reserved for angel dancing on the heads of pins. And then at paragraph 34, Lord Justice May says there are now 8 circumstances. Now there are 9, but the fundamental categories still remain good. He says that 8 circumstances in which section 193 provides the local housing authority shall cease to be subject to the duty. They fall roughly into 3 groups. The first group, subsection 6A and B, comprise circumstances in which the criteria in section 1931 ceases to apply. The second group, and here we have 5 6D and 7 comprise circumstances in which the applicant has acted to frustrate the efforts of the local housing authority to overcome their homelessness. The applicant refuses or voluntarily ceases to occupy suitable temporary or permanent accommodation secured for him. So in Lord Justice May's judgment, when you are frustrating the authority's performance of duty, what you've done is you've ceased to occupy suitable temporary accommodation. And that point is referred to again at paragraph 35, where there's a clear contrast between the second group, where the duty ceases because the applicant refuses an offer, and the third group, where the duty ceases because the applicant accepts an offer. Those who refuse suitable accommodation are acting unreasonably. Those who accept are no longer homeless. But again, there is the reference to the refusal of suitable accommodation.
From the wording of the section itself, one can see that is to some extent shorthand.
Yes.
Because in relation to refusal, what the authority must have done is informed of the consequences of refusal acceptance and of the right to request a review of the suitability. That seems to really anticipate that the accommodation may not in fact be suitable.
Yes. So that caters for a situation where there's, as we said earlier, where the accommodation has been refused, whereas 6 refers to the situation where the accommodation hasn't been refused, but something else happens, which means that the authority can say, well, our duty has come to an end, without a refusal being made. So there is no inconsistency here in my submission.
I think the point you're making is that certainly Lord Justice May appears to have treated all of this as a package.
Yes.
He reads all of these provisions together and as a whole.
They're a complete code. And 1935, for example, is dealing with the consequences of refusing. Yes, my lord, I don't think that's the same.
Right.
But
anything else on this judgment?
not on. No, nothing more.
Right. Thank you.
And then going back to the point, well, if it had to be suitable accommodation, it would have to be included in the statute. Parliament itself would have said, voluntarily ceases to occupy suitable accommodation. Well, that's a point without substance for the following reasons. Firstly, if we look at section 188, which is at page 15, this is the interim accommodation duty, i.e. before the local authority accepts the main housing duty. It's a mandatory duty. 1881 says they must secure that accommodation is available for the applicant's occupation. So there is no reference to the word suitable there. But if my learned friend is right, the authority could perform the 188 duty, which is a function under Part 7 for the purpose of Section 206, by providing unsuitable accommodation, because the word doesn't appear. But
so never mind someone with disabilities.
Yes.
Your submission would be that they could make accommodation available for the applicant's occupation, but it doesn't have, for example, a toilet or washing facilities.
yes,
And you would submit that unless one, is this right, that you have to imply the requirement of suitability into this provision, otherwise it makes no sense.
they have to be read together. Whenever an authority is performing a housing function,
Under section 206.
under 206, you have to read 206, and
I mean, that in itself is a form of shorthand, which having been set out in that provision, the draftsman didn't need to keep repeating.
And, my lord, the point was addressed by Baroness Hale in Alley in Birmingham. And this is at tab 7, at paragraph 18, page 107 of the bundle of authorities.
Sorry, I'm not keeping up with you. Which
No.
page?
Page 107, it's tab 7,
Yeah.
paragraph 18. Apologies.
Paragraph 80.
18, 1-8.
18, sorry. Lady Hale.
Where the authority is securing interim accommodation pending decision 1881, we've just seen that, or securing accommodation after the decision has been made under 1932, they may provide the accommodation themselves or secure that it is provided by someone else. However, the accommodation secured has to be suitable. So I accept that doesn't deal with 1936D, but it does deal with 1881, which doesn't include the word suitable. And there, if authority is required, and I say where the authority isn't required, it's a very basic piece of statutory interpretation.
But it does deal with 1932.
It does deal with 1932. And so it's the question just logically arises. If you're not lawfully performing the duty, how can you say the duty is ended? And that takes my lord to the point about well, there's one other authority I'm going to go to before I go to that. So although 1936D has never been examined by the court, the higher court, certainly as far as I'm aware, 1936B has been examined, and that's the case of Best, which is at tab 8, a decision of Mrs. Justice and Mr. Geraldine Andrews QC as she was then. This case is a somewhat unusual and odd case, and perhaps the facts do not assist us very much in this case. But if we go to paragraph 20, and these are paragraphs I do rely on. Once the authority have concluded that an applicant satisfies the criteria in section 1931, they are not entitled to revisit their decision save on grounds of fraud or fundamental mistake. So you can't change your mind even if circumstances subsequently change. For example, if the applicant ceases to be a person with private need. The duty of the council is to provide, set out section 206, they must provide the applicant with suitable accommodation or secure that some other person does so. So this was a case where Mrs. Best was arguing that to be suitable, accommodation had to be provided to her at a peppercorn or zero rent because she said, I can't afford anything more than that. Now that's dismissed by the judge as a challenge. But interestingly, what she says at paragraph 23, it follows from the statutory provisions to which I've referred that the duty to provide suitable accommodation, with or without charging rent, is an ongoing duty that can only be brought to an end by the fulfilment of one of the statutory grounds set out in section 193, which includes the situation where the applicant makes himself intentionally homeless. Therefore, the question whether the accommodation is suitable has to be addressed before there can be any determination of whether Miss Best has made herself intentionally homeless. If the accommodation is not suitable, then section 1936B cannot be relied upon, even if the applicant fails to pay the rent. And again, in our submission, that analysis also equally applies to 1936D.
As I understood Mr. Manning's submissions earlier this afternoon, he appeared to accept that interpretation of paragraph B.
Yeah.
They asked him.
Yes.
And your fundamental submission that paragraph B does not expressly use the word suitable either.
Yes. And of course,
What it really comes down to is each time accommodation is used in 193, it's shorthand for suitable accommodation.
That's right, because only suitable accommodation can be made available under section 1932. 1932, 1936D and 206 have to be read together. And it's a very short point. Mr. Manning's construction, where he accepts 1936B, but not 1936D, would also lead to this absurd situation, where a person who leaves accommodation is unsuitable, causing the authority to say cessation of duty. That person would apply as homeless again. They couldn't be found to be intentionally homeless because, let's say for the purpose of argument, the accommodation is not reasonable for continued occupation, which is a test in section 191, which case the duty would have to come back on.
Sorry, you said the last bit again.
Yes. So let's say Mr. Manning is right,
Yeah.
but there's a fundamental difference between 1936B and 1936D. So a person leaves completely unsuitable accommodation, and the authority serves a discharge of duty letter, and the person then applies as homeless again. Hang on, look, there was no toilet in this place, that's why. The authority couldn't say you're intentionally homeless because that accommodation was not reasonable for continued occupation. So either the duty would have to flicker back on, and perhaps really we are now beginning to dance on the head of that pin, or there would have to be a new duty accepted. But in any event, it just cannot be the way that a social welfare scheme works for homeless people.
Mr. Manning posited various hypothetical scenarios, which he says that unless they fall within paragraph D, would not bring the duty to an end at all.
Well, look, if one just,
The examples are, you go to Manchester because your new partner happens to live in Manchester, or you win the lottery and you decide to go to Australia.
well, look, with respect, I think a degree of realism has to be actually. Let's say the person goes to Manchester because they've won the lottery and they've had enough of Birmingham. What the authority would do in that situation, the authority would serve a cessation of duty notice on them. They would say you voluntarily cease to occupy, accommodation made available for your occupation. And if the person doesn't seek to review that decision within 21 days, that's a good decision at law and the duty has come to an end. If the person seeks to review that decision and the authority says, well, no, you voluntarily left and the accommodation was suitable, the review succeeds. If the person requests a review and the authority finds that this is the only situation in which perhaps there could be some force of mistake, and the authority finds you voluntarily left unsuitable accommodation, but you voluntarily left unsuitable accommodation and have moved to suitable accommodation. I mean, it's very difficult to imagine a circumstance where someone who had done that would request a review in any event. But if they did, and I thought about that, perhaps the authority could rely on section 2061C, which is at page 26. By giving them such advice and assistance as will secure that suitable accommodation is available from some other person. So in that case, the authority would say, well, the advice and assistance we give you is to carry on living with your girlfriend in Manchester because that's enabled you to secure suitable accommodation. But in that last example, if I'm right, voluntarily ceasing to occupy unsuitable accommodation doesn't cause the duty to cease. So the duty remains even though you've left. Then the question is, how does the authority perform that duty? And the authority performs that duty via section 206. And one of the ways, it doesn't have to provide accommodation itself, secure that accommodation is available, and give advice and assistance. And that's what we would do in that scenario. Now, we are really at the extreme spectrum of possible examples. And the fact that no one can point to a single case in the higher courts where 19360 has even been a subject of any discussion. Sort of illustrates how bizarre the argument has to be.
Let us come back to the statutory interpretation. Though I think the effect of 206 must be to read in suitable in 1932.
Yes.
I don't think you can do that in 5A, can you? It wouldn't make sense. The applicant having been informed by the authority of the possible consequence of refusal, acceptance, and the right to request a review of the suitability of the accommodation, refuses an offer of suitable accommodation which the authority are satisfied is suitable.
But my lord, the way that works, and this is a very common occurrence, so you will have someone will refuse an offer. The local authority will then write a letter saying, we consider our duty towards you as ceased because you refuse an offer of accommodation that we consider is suitable. And let us say they uphold that decision on review. That would then be challenged in an appeal under section 204, where if, for example, and if the court were to find that the authority's decision on suitability is unlawful, the authority would then be under the duty again. So in that scenario, where there's a refusal, the duty has ceased because of the letter. But if there's a successful challenge to suitability, otherwise, my lord, there'd be no point in having section 202. If one looks at 202(1)(b), which is at page 20, you can request a review of any decision as to what duty is owed to you. And 202(1)(b) also, and then you also have F, any decision as to the suitability of accommodation offered to him in discharge of their duty under any of the provisions mentioned in paragraphs B or C.
So your point is that if you don't read suitable in there,
yeah,
then all that warnings about the right to have a review, etc., are for nothing.
that's right. And so what happens, and this is very matter of fact, is that the county court can quash the cessation of duty decision and ask the local authority to reach it again. That is a very common happenstance. Because otherwise, again, you'd be left in this absurd situation where the authority is marking its own homework. It writes a letter saying, we're satisfied this accommodation is suitable, our duty to us come to an end. And finally, on this point, if the duty can cease by the applicant leaving unsuitable accommodation, then the authority will be taking advantage of its own legal wrong. And that has been deprecated by this court. And just by way of example, Robinson and Hammersmith and Fulham, which is at tab 5, starts at page 68. And my lord, very briefly, the facts of this case were, so if I stop, if you are under 18 and over 60 and you apply as homeless, you're automatically in priority need. Miss Robinson, I think it was, she applied to the council when she was 17, and the authority effectively delayed matters and didn't reach a decision until the day before her 18th birthday. And it said, well, we find you're not in priority need because there's only one day left, and that's de minimis. And the Court of Appeal found that there's no chance of applying the de minimis principle here, either you're 18 or you're not. But in the more important point was that as of the date of the review decision, the appellant, Miss Robinson, was over 18. So if you're going to consider the position as at the date of review, she would not automatically be in priority need. And the Court of Appeal said, well, that's not right. You cannot take advantage of your own lawful wrong. And that was a submission made by Ms. Robinson. We see that at paragraph 28, which is at page 75.
Sorry, page 75.
Page 75, paragraph 28.
Thank you.
Mr. Arden's main point was that it simply cannot be right that the reviewer can ignore an unlawful decision which would have given the applicant a right to accommodation. You must hold that the original decision was unlawful and restore the applicant to the position she should have been in. It's wrong to say, well, she's over 18 as at the date of the review decision. And
that's council submission.
yes, and at paragraph 32,
Right.
page 76, the decision review would not have been lawful if it had simply stated the applicant was now 18 and thus not in priority need. If the original decision was unlawful, which for the reasons I've already given it was, the review decision maker should have so held and made a decision that would have restored to the applicant the rights she would have had if the decision had been lawful. And the proposition I get from that is that the authority is not permitted to take advantage of its own legal wrong.
Right.
My Lord, in their skeleton, the local authority at paragraphs 44 to 50 refer to policy reasons about suitability and say, well, suitability is quite a difficult thing, and things can be both suitable at one point and then unsuitable, and therefore it's too difficult to effectively import suitability into 19316. But my Lord, in my submission, again, this is a misconceived argument. The duty has to be lawfully performed. Exactly the same exercise would have to be carried out for 1936B, because the authority would have to determine, is this accommodation reasonable for continued occupation at the time that it ceased to be occupied? So, if it has to be done for 1936B, there's no reason why it cannot be done for 1936D. That's not a valid reason. Secondly, when an offer is refused, and there's authority on this, it's a case called Sally. When an offer is refused, suitability is to be assessed as at the date of refusal, whereas where an offer is accepted, suitability is to be assessed as at the date of the review. So in cases of refusal, the authority is having to carry out, again, a post facto exercise, having to go back to when the offer was refused and determine whether the accommodation was suitable at that point. But this is something that local authorities do all the time. It's not something novel or new. And then at paragraph 47 of his skeleton, he says there's an anomaly, because if you accept an offer of assured or secure tenancy, then the duty ceases irrespective of suitability, because if they leave because they have found their own permanent accommodation, the duty does not cease unless the 1932 accommodation is suitable. Well, I have to say, I didn't really understand that argument, but in my submission, as much as I can understand it, it is wrong. The duty does not cease simply because someone accepts an offer of an assured tenancy or a secure tenancy. These days, whenever a local authority makes an offer of accommodation, it always has a warning at the bottom, which is that you can request a review of suitability of the offer, whether you accept it or refuse it. And people are advised not to take a gamble by refusing an offer. That if the local authority is right, and it is suitable, the duty has come to an end. But if you accept the offer and request a review, that avoids the gamble. And if the decision subsequently was that the accommodation is not suitable, then the duty would not have come to an end. it would persist. So there's no anomaly. My learned friend in their skeleton also make this point about, well, look at part 6. Once someone is owed a main housing duty, then they get priority under the allocation scheme. And if someone just leaves with an open-ended duty, then they would have a priority they're not entitled to. Well, assuming this could ever happen, the very simple way the authority deals with that is by serving a cessation of duty notice. And that's it. Well, I'm going to move on. I'm conscious of time. I'm going to move on now to issue 2, unless there's something else, anything further assistance I can give on the 1936B. So, my first submission is that the judge was entitled to find, on a public law analysis, that the authority had either accepted or concluded that 7 Holden Close was not suitable. And the reason for that, there are several reasons. First of all, the letter of 4th of June, my Lord, I won't take you to it again, but in my submission, that letter is a clear acceptance that Holden Close, in the condition it was in, without an adaptations, was not suitable. Otherwise, as was asked, what would have been the point of carrying out the adaptation? As of the 4th of June, the local authority was saying the works will take 4 weeks. That was the position that faced His Honour Judge Williams when he, and we haven't heard very much about this, but when he made his order, interim mandatory order.
It's at the back, isn't it, of the bundle?
Yeah, page 259. Actually, it's in there twice. So the first point to note is that this order, the interim mandatory order, was not appealed.
Yes.
And that's not without significance.
No.
Secondly, what was recorded? This was the judge's judgment. So, in terms of 4th of June, he deals with it in paragraph 9, my lord. I just want to make this point. The defendant filed no acknowledgement of service, filed no summary grounds of defence, and filed no evidence with its detailed grounds of existence. So when my learned friend says, well, perhaps it could have, the defendant could have, the appellant could have conducted itself with more rigour, that very much understates the point. Anyway, paragraph 10. This is the reference to the letter of the 4th of June, and the judge finds, after having heard submissions, the defendant acknowledged that the accommodation was not suitable and an urgent request was made for works to be completed within 4 weeks. And then at paragraph 12, he says it's unarguable that the defendant is and has been for nearly 12 months in breach of its statutory duty. Then at paragraph 13 he says, Claimant and her brother are living in intolerable and frankly degrading conditions. And then he says it's stated, and then at the bottom he notes that the defendant has repeatedly stated, and again it is stated at this hearing, that it intends to undertake planned works to render the property suitable, although no firm timescale or indeed schedule of works can be produced as to when and what works will be completed. And then paragraph 14, the defendant says, don't make an interim injunction where it's taking all reasonable steps, and the court rejects that, doesn't accept they're taking all reasonable steps. saying the difficulty how the defendant acted reasonably, making an offer of suitable accommodation at and moving the claimant and her brother into Sudden Holden Close, and then immediately conceding on their arrival that the property was not suitable. And the reason that the judge gave 21 days for the order, so they had to provide suitable accommodation by the 16th of July, was because the 28 days that had been said in the letter of the 4th of June, that work will be done, and he gave them a little bit more than that. So that was material the judge was entitled to take into account when exercising judicial review. Secondly, the judge was entitled to take into account that as of the date of the hearing before him, the works to 7 Holden Close had not been carried out. Thirdly, my Lord, you will have seen His Honour Judge Williams's order, which is at A158, page 207 electronically, that the court ordered, paragraph 2, the defendant must secure suitable accommodation for the claimant pending the outcome of these proceedings or further order. The judge simply wouldn't have made that order if the court had concluded that the respondent was already in suitable accommodation. And I said there was no appeal to this order. And that's why we have because the judge suspected that the works might not be complete, that's why paragraph 3 said, arrange or facilitate transport and provide moving assistance. Thirdly,
But sorry, can it be said that although accommodation may not be suitable in the long term,
yeah,
that with appropriate short-term modifications or mitigations,
yeah.
that it is overall suitable?
Well,
So for example, if you take, to simplify matters, we've both been postulating the hypothesis of a non-disabled person, just an ordinary citizen, of course needs a toilet.
yeah,
And the accommodation does not have a toilet.
yeah.
But they say, we'll put a toilet in as soon as we reasonably can. We're onto it.
Yeah.
But in the meantime, here's a chemical toilet for your use. Could that mean that, I think Mr. Manning is making the submission that this was in substance what the letter was saying. It wasn't conceding that the accommodation is unsuitable. It was saying when you take the current state of it with appropriate mitigations, it's not ideal, but it's okay for the time being, and we're also doing the longer term works. What's wrong with that way of looking at things?
Well, if the works had been done in the 28 days that the letter of the 4th of June suggested, then there would be no problem, because they would have complied with this order, and they would and the case would have stopped. It would have ended. The reality is, we have the findings of Honourable Judge Williams, and then we have this order, which orders suitable accommodation to be provided. So there's effectively a finding that the accommodation is not suitable as at the date of the interim relief hearing, which is not appealed, and that's why we have. And then let's see what the authority do. On the 16th of July, when the works have not been completed, what do? They don't say you can carry on living at 7 Langdon Walk. 22 Langdon Walk, because the mitigations we've put in place have been adequate. They offer 22 Langdon Walk on the 16th of July, which is the last possible day for compliance. And that letter, the offer letter, is at supplementary bundle D1 to D6, electronic page 240.
And what's the point you're making?
The point I'm making here is, if the authority's case all along was, our letter of 4th of June meant that this accommodation, 7 Holden Close, is suitable with the mitigations we put in place, then why on the 16th of July, to comply with the order of the court to provide suitable accommodation, do they offer alternative accommodation at 22 London Walk? Implicit in that offer is an acceptance that they accept the findings of the court at the interim relief hearing. And then, when they actually realised, or we already accepted 22 Langdon Walk was not suitable, that's then withdrawn, and then they offer the hotel, the Ladbroke Hotel. They don't say, well, 7 Holden Close is suitable. And the offer letter for the Ladbroke Hotel is at D7 to D9, 246 to 248.
22nd of July.
Yes.
Right.
So, my Lord, the submission I'm making is one looks at everything together. I just don't rely on the 4th of June. One looks at the history. The judge exercising the public law approach had all this material in front of him. And that's why we say he was entitled to reach the conclusion he did, or would have been, even that your lordships find there was some flaw in the way that he actually expressed himself. He would have been entitled to do it on a public law analysis. And we can, in terms of Ladbroke Hotel, our submission is that the judge was entitled to find that offer was withdrawn for the reasons that he gave. And in fact, Nita Gill in her witness statement accepts that the offer was withdrawn. At paragraph 5 of her witness statement, which is at supplementary bundle B57, paragraph 5, says it was kept open from 22nd of July until the 22nd of August. But actually, on the material before the judge, it wasn't an issue that the original moving in date, 30th of July, was postponed because there was no occupational therapist report and no new moving in date was notified. And so the appellant, the respondent, neither accepted nor refused the Ladbroke Hotel. It's also relevant that the Ladbroke Hotel is not used for any discharge of duty letter. If the authority concluded that the Ladbroke Hotel was suitable and that they'd refused an offer of suitable accommodation, it would have issued a discharge of duty letter at that point. And then, my lords, again, in looking at the way what was before the judge, there's been some mention made of this already this morning, but the detailed grounds of resistance are important. And I accept what Mr. Manning says, that he didn't settle them, but nonetheless, they are the appellant's detailed grounds, and they are at A149, A157, which is electronic page numbering 198. And the paragraphs in particular we would wish to refer the court to.
Yes, which paragraph?
Paragraph 24, A153, which is a reference to the interim hearing. The provision of suitable accommodation might include carrying out works of property at 7 Holden Close to render it suitable. And my lord, there was a time in Mr. Manning's submissions, I think this afternoon, where he nearly said that, to render it suitable, and then I don't believe that he did. But this was the authority's own case, that it was the works that would make the property suitable. And then paragraph 28, in light of the lack of any other available properties and the need to comply with the court order and to decant the claimant to carry out works, other accommodation was offered. But the important point there is in order to comply with the court order. Now, to be fair, just say at paragraph 30, the defendant adverts it has not breached the order. The former property is suitable for the short period for which it will be occupied pending works and was secured. Yes. But this former property is not 7 Holden Close, it's 22 Langdon Walk. And then at paragraph 35, it says that except...
That's clear at 27 line 3. Former property at 22 Langdon Walk.
Yes.
It says so explicitly.
Thank you. Then paragraph 35, acceptance has got to be provided suitable accommodation, and that said the defendant has attempted to do so. And then at paragraph 39, the detailed grounds say, the background set out above demonstrates the impossibility of compliance with the duty to provide suitable accommodation. And then paragraph 40 says, there were simply no available suitable properties for the claimant to occupy. 40. And then again at paragraph 41, the defendant simply has been unable to find any suitable properties.
Yes, I also note in passing that this section is headed submissions.
Yes.
So I may have read this document too quickly when I was preparing for this hearing, but I'd certainly read the written arguments that were put to the judge as really focusing on the discretion arising under Imam.
Yes.
And in other words, we're doing our best.
Yeah.
Don't make us do the impossible.
That's right. That's what happened at the interim hearing. And that's then supported by the interim hearing. That hearing, I think, took place on the 25th of June. And then these detailed grounds are the 31st of July. The authority had a bit of time to consider its position, and it's still saying the same thing.
And the skeleton for the substantive hearing is quite short and relies on the detailed grounds.
Yes. Now, bearing in mind that they serve no evidence with their detailed grounds, and it's only when we get really Mr. Manning's skeleton, I think it was very shortly before the hearing, the day before, that we realised that there's been a change in approach as to how this case is being argued.
No,
Perhaps that's unfair to Mr. Manning. Perhaps it was an error on our part. Perhaps it wasn't. But certainly I perceived it to be a change of approach in now seeking to rely on 7 Holden Close as being suitable. Because our energies have been focused on not focusing on 7 Holden Close, but either trying to get the works done to 7 Holden Close, or to say you're in breach of duty and you haven't taken any reasonable steps. The Imam point, which does require the judge to look at the facts and objectively and the court come to its own decision as to whether all reasonable steps have been taken or not. So if we don't admit the judge fell into error, but if he fell into error, he was not assisted by the evidence, lack of evidence from the local authority and the local authority's approach and pleadings.
This is going back to the Imam case. That is dealing with the court's discretion on remedy, but it's subject to a prior issue as to whether there's a breach of the duty.
Yes.
And it's at that stage that the appellant says judicial review principles are applicable.
Yes. And my lord, I accept that.
So it needs to be set out quite carefully for the judge.
It does need to be set out quite carefully, but this is the difficulty you have, where the detailed grounds of resistance, which is something the judge would have had in his pre-reading, really focusing on how there's no suitable accommodation and it's impossible to comply with the duty.
But maybe the difficulties would be lessened to an extent if an applicant for relief doesn't go off for judicial review but asks for an internal review under section 202 and then pursues the matter in the county court, because there you have a reasoned decision of the local authority, warts and all. It could either be good reasoning or bad, but there'll be something to go on.
My lord, sometimes I would certainly see the force in that. But on other occasions, one is dealing with an emergency situation. One, as my lordship is aware, one power the county court lacks is to make a mandatory order. So where you're seeking accommodation, the only remedy available to you is to go to the administrative court.
Sorry, I misheard you. Under the county court...
Under the county court, section 204, subsection 1, sets out the right of appeal. And I think 204, subsection 3, sets out what the powers of the court in the county court.
And your submission is that there's no power to grant mandatory relief?
There isn't. All the court...
Final or interim?
No. The court can confirm,
Quash or-
vary or quash.
Yeah.
Those are three.
I noticed that language when we were taken through it.
Yeah. So
But,
that's
but
why.
that would suggest that actually Parliament envisaged not that JR would be exceptional, but actually might be quite common, because I'm afraid that the sad reality of society is such that often people are going to find themselves in need of urgent mandatory relief.
Well, there are a number of cases. The part, for example, under section 188, subsection 1, which is the duty to provide interim accommodation.
Interim accommodation.
There is no right for review or appeal of that. If you challenge a 1881 decision,
It's JR.
it's JR.
Yeah.
The Merton compliant letters.
Yes. And then 193 again. Often in 193 cases at the moment, because of the resource issues that we have, and I've done a number of these judicial reviews myself, there is never any argument about whether accommodation is suitable or not, or whether there's a breach of duty or not. And the focus of the case is always on, has the authority taken all reasonable steps? And that was the way that, until very late in the day, we say this case was being
All right. I think you're still on your second issue.
I'm still on my second issue, but
Again, I want to start gently nudging you,
fine.
as I did Mr. Manning earlier.
My lord, I will finish my four.
Good.
So, in fact, I've nearly finished with issue 2, and I'm going to move to issue 3. So our submission is that there was plenty of material in front of the judge to enable him to conclude that either the authority had accepted that 7 Holden Close was unsuitable, and therefore he was dealing with the question of what relief should be granted for them, or if there is an error in his approach, in that even if he had directed himself correctly or had been directed, but to be fair to the judge, it wasn't put to him. For example, the well-known the principle, for example, the defendant's evidence is to be preferred, but one must have some sympathy for the judge, because no evidence was filed with the detailed grounds of resistance that the judge could have considered. No evidence was filed within the time limit provided for by the court order. There was a late application of relief from sanctions without any proper reasons being given, and the court refused relief. to some extent, the authority only has itself to blame. And my final point on issue 2 is that even if you look for against me on all the arguments I've made so far under issue 2, and my final point is this, that on a public law basis, the judge would have been entitled to conclude that no reasonable authority could have decided that occupation of 7 Holden Close with the temporary accommodations, temporary arrangements described at para 60A of his judgment would have been suitable for anything more than the 4 weeks the authority itself had proposed in its letter of the 4th of June. And again, repeated at the hearing before Judge Williams. Given His Honour Judge Williams' findings that the conditions were degrading, and certainly not for the period of 4 months that has elapsed since then, there's still no end point in sight. And there was no evidence before the court from Birmingham to say, well, 7 Holden Close was suitable with the temporary arrangements. And again, so I say for those reasons, both the Ladbroke Hotel and 7 Holden Close, the judge was entitled to find on a public law basis that they weren't suited. So then I move on to issue 3, which effectively jurisdiction. Well,
it's not jurisdiction.
Well, it's not jurisdiction.
It's the adequate alternative remedies.
It's alternative remedies, residual discretion. Was the judge correct to consider duty of cessation of duty and or the suitability of offers of accommodation? But firstly, my lords, we accept that the general rule is that where there is an alternative remedy, permission to proceed by way of judicial review will only be given in exceptional circumstances. Now, the short answer to that is, in this case, permission to proceed for judicial review had been given. Secondly, the detailed grounds of resistance did not raise the issue of alternative remedy. What comprises exceptional circumstances is at large for the court. So the availability of an alternative remedy does not of itself mean that the court cannot exercise its residual discretion.
The alternative remedy has to be adequate.
It has to be adequate.
Right. Now, could it be argued that because the county court lacks the power to grant a mandatory order, it's not adequate?
Oh my God, that was one of the points I was going to make. Yes. On the facts of this case, it just wouldn't have been adequate. A, because the county court can't make a mandatory order. B, because the local authority are arguing that 1936D, that accommodation doesn't need to be suitable. So they would have argued it didn't matter whether 7 Holden Close was suitable or not. If you've left it, the duty has come to an end. But once the judge had made his finding on 1936, let's just, if one thinks this through, if I'm right or if the judge is right in his construction of section 1936D, and if he's on a public law, he was right to find that either that the authority had accepted that 7 Holden Close was not suitable, or he could have concluded on a public law basis that 7 Holden Close was not suitable. What is there left for a review and or statutory appeal to do? This is not one of those cases where a person has the choice of 2 remedies and decides to go to the High Court, leaving aside another remedy which you're meant to take. And it's not, the timing of the decision is not irrelevant. All the work had been done, the evidence had been prepared, the issues were before the court. All a review and or appeal would have done would have built in further delay in a case where there had already been on the respondent's case egregious delay in providing her with suitable accommodation.
I don't know if this is too simplistic a way of looking at it, but you've taken this issue third,
Yeah.
but arguably it's actually the first issue, because if you shouldn't be embarking on this case at all, because there's no alternative remedy, is that one way of looking at it?
Well, my lord, I respectfully disagree with that. I think it has to be in the way that I suggest, because you only get to the question of whether the remedy is adequate on the facts of a particular case once the issues have been analysed. And even if one deals with it first, which is not really the way that it was argued before the judge.
I appreciate that.
Yeah. But even once it took this point first, I would argue that in this case, it would not have been an adequate remedy, because it would not have achieved the relief that was essentially being sought.
There are separate issues going on here. Picking up my Lord's question, the question he raises is one which is, I would have thought, to be answered at the outset of the judicial review proceedings, as opposed to the situation that substantive hearing judges presented with when the trial comes up. I mean, your analysis, which is on the basis of we won on these issues, that therefore colours the merits of the argument, as my Lord is suggesting. Question being, should this have happened in the first place? Because otherwise, the argument you're presenting would hold good for challenges to local housing authority decisions generally. And the High Court would be overloaded.
Well,
but what sets this apart, your final point, is the nature of the relief being sought.
yes.
So how does it differ in principle from cases like Banno, where it has been held that judicial review ought not to have been deployed?
So the facts of Banno, well, it's worth bearing in mind, I think, that Banno has been heard by the Supreme Court.
But on this point?
But not on this point.
I mean, if I respectfully say so, what we were shown in Banno, as I suggested this morning, is trite law. Yeah. Okay, may not have been applied to this specific statutory context, but for 40 years, at least, it's been a general principle of administrative law. That if there's an adequate alternative remedy, you are expected to use it. Judicial review is a remedy of last resort. There is a residual discretion. So it's not a question of jurisdiction. So all of that is well-trodden law. So if you're right, one would expect that pretty much in every housing homelessness case, judicial review, in fact, is available.
My Lord, there are exceptional features in this case,
Right.
because you had the interim application. There's an interim mandatory order has been made.
That's not unusual at all. When I was the duty judge overnight in the High Court 10, 15 years ago, I mean, this was routinely, sadly, the kind of case one had to deal with overnight.
Well, I think possibly a number of them were the Section 188 cases, were they? I think I came across those quite a lot.
Yes, you would have come across 188.
Yes.
My Lord, when you that of the duty judge, I expect most of them would have been 188 cases.
Right.
Where someone was homeless and was
But,
seeking...
but even if those experiences were like that, the sort of problem which arose in this case, I'm not suggesting it may be common, but it may not be unusual. Which I think is where my lord...
Yes, that's
Well,
fine.
again, in my submission, the facts of this case are fairly unusual. And that would be our...
Is it because that it's difficult to get the mandatory relief?
Well, you cannot get... What
applying imam and so on?
Yes, what the respondent needed in these proceedings was an order that she be provided with suitable accommodation. There had been a finding of the court, judgment of the court, which was not appealed, that 7 Holden Close was not suitable accommodation. There had been no change in position since the judgment of His Honour Judge Williams. That, in my opinion, takes this case out of the ordinary. And then the way that the detailed grounds were put was that it was impossible for the defendant.
I'm sorry to interrupt you, but this is begging the question that even the interim order was appropriate, because if you shouldn't be using judicial review, you shouldn't be using judicial review.
But Muller, the only remedy available is judicial review. If you are seeking mandatory order for accommodation, there is no other route apart from judicial review.
Well, that's a very short, simple, and clear submission, and that may be the end of the case, or at least the end of this issue. And that's all you need. You just say, as I said about 10 minutes ago, the principle is not whenever there's an alternative remedy you have to use it. The principle is if there is an adequate alternative remedy, you are expected usually to use it. Your submission is it as simple as this? There was no adequate alternative remedy because the county court has no jurisdiction to grant a mandatory order.
Yes.
Right, well, I'm not sure how much more we then need. If that's the, I mean, we may not accept that, but
No.
that's the submission, is it?
Well, may I just...
Are you going to show us Banner to say it's distinguishable? Because obviously that's binding on us because it's a Court of Appeal decision.
Yeah.
So you have to persuade us it's distinguishable.
Well, I accept the principle, my lord, but the facts of Banner are a million miles away from the facts.
In a nutshell, why are they a million miles away?
Because that was a case where, well, if I may take you to the head note, I think that's 285, tab 16. So the homeless application main housing duties accepted and is performed by the making of a private rented sector offer. So the claimant refuses the offer, but doesn't seek a review within the 21-day statutory time limit. Over 2 years later, the authority said, in response to a letter from the claimant solicitors, that its duty had come to an end because of her refusal. And so the claim for judicial review was allowed on the basis that the main housing duty hadn't come to an end because the authority had not made a decision that the duty had come to an end. And so what the Court of Appeal is dealing with is, well, did you have to send a formal notification for the duty to come to an end? And it was held, no, you didn't, because the duty automatically came to an end. But it was a refusal case where there was no review of the decision to make that offer of accommodation. So it really is, perhaps that's too colourful a way to put it, a million miles away. It's a very different sort of case where there is this, where there's, after the offer was made, there was no request for review. And at that stage, there are no judicial review proceedings. They're only brought 2 years later when the authority says, oh, well, because of your refusal, our duty has come to an end. And the Court of Appeal found, no, the duty came to an end when you refused the offer, not when the authority notified you of its decision. And therefore, you can't proceed by way of judicial review because you should have proceeded by way of review. So chronologically, it's very different. Well, may I just make a few more points as to why we say this fits the exceptionality test with an eye on the clock. So firstly, the issue about whether the duty had ceased, the discharge of duty decision, it arose during already extant judicial review proceedings. It wasn't a freestanding decision. It's part of the factual matrix. Not a case where you get a decision and instead of going for a review or appeal, you go for judicial review. The issues were all already before the court. Including number 2. The respondent wasn't using the judicial review procedure as a way to shortcut any statutory limitation. Often, for people, not so much anymore since the Court of Appeal put a stop to it, but where people didn't apply for a review within 21 days, they would then seek permission to judicially review the same decision. And the courts have said, well, you can't get beyond statutory time limits in that way. This isn't one of those cases, because actually, by the time of the judicial review hearing, it was still within 21 days of the date of the discharge of duty decision.
Sorry, by the time?
By the time of the judicial review hearing, 21 days had not elapsed from the discharge of duty decision. So it wasn't a case of the respondent being out of time and seeking to use judicial review as a way to avoid the consequences of being out of time.
Because that notice came relatively late in the day.
It came very late in the day. So I think it was 5th of September. 22nd of September. It's very shortly before the final hearing. And well, we say the claim was urgent and of acute importance to the respondent, and a review, statutory time limit for review is 56 days. So it's not, very rarely are reviews completed within 56 days. Often extensions of time are sought, which is permissible under the review regulations. If one thinks about what would have happened, the review done at least 56 days for a review decision.
So is that in evidence?
Is what in evidence?
That they are not usually completed within 56 days?
It's not in evidence. That's me
How can we take that into account?
impermissibly giving evidence.
All right.
So perhaps the most I can say is that the review regulations allow up to 56 days for the making of a decision on review, and also allow for that time limit to be exceeded by the written agreement. So assuming the 56 days, then there will be a review decision. Then there's another, then you have 21 days to bring an appeal against any decision. And then, again, I asked the court to take judicial notice that from the issuing of an appeal to the hearing of an appeal would again not be an insignificant period of time in the court. But I agree that all these points might not be sufficient in the usual case. But my specialty, this is an exceptional case. A, because of the facts of the respondent. B, because of the timings of what happened. And C, because of the judgments that the court had already given.
Can you just help me with this, Mr. Naveed? I'm not talking about this case, but in principle, can the High Court grant a mandatory order, in particular an interim mandatory order, in support of the review and county court process? Have you ever come across that? Maybe an unfair question.
I've never come across that.
No,
And the reason for that is, my lord, that often, so first of all, when the question, actually, there is a sort of answer. The answer to that is yes, qualified. So when you apply as homeless, you should be provided with interim accommodation under Section 188.
Yeah.
The decision goes against you, you can request a review. There is then a discretion to continue to provide accommodation under 188 subsection 3. If the local authority says no, we will not exercise our discretion, then you have to go for judicial review. And then the case of Mohammed.
That was the name of the case, not Merton,
Mohammed. And there's a 1883.
Yeah, sorry.
So in that circumstance, we would be going for judicial review to obtain relief that would grant you accommodation. Plus in the country.
I think that's the kind of case I had a vague recollection of.
So in this case, we were way past the 188 stage and the 188. We're at the 193 stage.
That's helpful. Given that you've got 1 minute on my clock and 3 minutes on that one,
Right.
Is there anything else you want to say?
May I just turn my back? My lord, may I just refer you again by way of chronology to this letter of the 5th of June 2025, which is in the supplemental bundle at page B21, electronic numbering 132. My lord, it's quite a lengthy letter. I won't go through it, but it sets out my solicitor setting out the chronology of the dealings with the council in respect of the respondent. You'll see it goes on for quite a while. And then at paragraph at page B25, electronic number page 136, it makes reference to the manifest unsuitability of the property. And then it says, you concede that, and this is the reference to the 4th of June 2025. And then in response to that, over the page, the page B25.
Yes, and you're now on B26.
And then B26.
Yes.
And those are the 4 bullet points at the top as to why the property cannot be suitable. I think the points that your lordship's already.
Yes. And the second bullet point, perhaps, is one that leaps off the page.
Yes.
May I check if there's anything else from my lords? Thank you, Mr.
Thank you.
Yes, Mr. Manning, if you want to reply.
Lord, just on that last letter, I think it's right. Find it that the detailed grounds set out that the local authority does not accept that. Paragraph 18 on page A152. it's not accepted that the front door is not accessible from Mr. Fowle. The property was checked by the occupational therapist and T18 in line with relevant guidance. So that particular allegation was not uncontroversial. My Lord, can I, in the short time I have, start by reply in relation to the whole adequate remedy point that my Lords have just been discussing with my learned friend. The case that the respondent puts forward, as I understand it, is that because the county court can't make mandatory orders, it renders it an inadequate remedy to adopt the review and appeal approach that I advanced this morning. But in my respectful submission, that can't be right. It would mean that in any case where an applicant said, my accommodation is unsuitable, that they could then say, well, that means that you're in breach of duty and I need a mandatory order, and simply bypass the entire statutory mechanism for resolving questions of suitability that Parliament has plainly mandated. It can't be right in my submission that an applicant could, simply by asserting that accommodation is unsuitable, not only bypass the section 202(1)(f right to seek a review, but immediately come to this court for relief.
To the High Court.
To the High Court. Under judicial review.
No, well, it wouldn't be simply by making the assertion. They would have to make their case good. And it's a high threshold before, even at the interim stage, the court will grant a mandatory order as opposed to, for example, a negative.
But bypassing the statutory mechanism would render it necessary for the High Court routinely to entertain questions of suitability.
Well, you say routinely, it might in a suitable case.
Well, but
Mr. Nabby says, in some cases it's raised as an issue, in other cases it's not raised as an issue. And he makes the simple submission that if it is raised as an issue, and it is a truth, you may deny this, I don't know, we'd like your help on it, but do you accept that the county court does not have the power to grant a mandatory order?
the county court does not have the power to grant a mandatory order in the way that the High Court does. Yes,
Well, could it grant any mandatory order?
Well, it can grant
under the County Courts Act.
in certain circumstances, it can grant the remedy of accommodation pending appeal. Don't think that would apply in a case
That's
like
actually
this.
in the Housing Act.
Yes, that's in section 204A.
Yes, I was wondering about that.
The court doesn't have before.
Yes, that's one of the reasons why that procedure is generally appropriate, isn't it?
It's one of the reasons why, in some cases, the requirement to seek an appeal is made. But, of course, in relation to a case of this sort, the county court doesn't have the power simply to make a mandatory order for breach of a section 1932 duty.
Do you accept that on the facts of this case, the county court could not have granted this respondent, for example, the interim remedy that she obtained from Judge Williams?
Yes.
Well, once you accept that, what's the basis for your argument that there's an adequate alternative remedy, which should have been used, rather than going to the High Court?
Because the statutory scheme, as held by this court in various cases, the latest of which was Banner, is that where there are disputes as to suitability and disputes as to whether or not a duty has been discharged, the remedy Parliament has provided and requires to be used. It's not simply a question of the court's discretion. This court has held that Parliament has required parties to use that remedy to resolve that dispute. It's not an acceptable alternative, in my respectful submission, to say, well, in this case it's different because I wanted a mandatory order.
Well, I was going to ask, I had a quick look at Banner. It didn't seem to be a mandatory relief case.
No, it wasn't, but that cannot be, in my respectful submission, the distinction. Because if it were, all a party would have to do is say, not only I don't agree that the accommodation is suitable, but actually I require suitable accommodation to be provided. So I'm not going to seek a review, I'm not going to appeal, I'm just going to come to the High Court and say, please can I have a mandatory order.
And if that was an unmeritorious assertion, the High Court could be expected to filter those cases out at an early stage. But we have to assume that it's a meritorious assertion. And even in such a case, you say the High Court cannot...
It will always be a meritorious assertion because it will always be the case that the County Court can't grant that relief.
No. This would, if it's handled properly, this would be handled towards the beginning of the process at the permission stage. So a prerequisite for getting interim mandatory relief is you've got an arguable case, at the very least.
And the arguable case would have to be that the accommodation offered was unsuitable.
Yes, but it would have to be an arguable case in terms of law. Not that I disagree.
And also, actually, in a mandatory interim case, it's usually said to be higher than reasonable. Yeah, it's a high threshold. Strong prima facie case is the language often used in the case law.
Yes, but my lord, with respect, I think we're confusing two things. One is whether or not the court could adequately case manage applications if they came in on a regular basis. The other is, what is the parliamentary scheme for resolving that kind of dispute? And in my submission, well, I have two submissions.
Yes.
One is, in order to, in the decided case, so for example, in El Kundi at first instance, which I'm not going to take you to, but
good, because it's not been referred to previously.
My lords have it, well, it's been referred to in the skeleton.
Yes.
My lord has it, I think it's tab 12.
Yes.
Mrs. Justice Stain specifically held that she wasn't going to entertain my learned friend's application for mandatory relief because there had been an offer made which the authority said was suitable, and the parliamentary scheme for review and appeal needed to be followed before it was clear that it was unsuitable. And in my respectful submission, that is an important point, that while a party may want mandatory relief from the High Court, it doesn't follow from that that Parliament intended judicial review to be the mechanism for determining suitability. All the cases in which mandatory relief has been sought and granted have been cases where there was no dispute about the suitability of accommodation, or there was simply no accommodation. Where there is a dispute about the suitability of the accommodation, public authorities, local authorities, housing authorities are entitled to the statutory scheme, the opportunity to review their decisions on the basis of the facts as they appear at the time of the review, and so on. And then the county court can consider them in an orderly way on the basis of the point of law as Parliament has intended. It's not, in my respectful submission, an answer to that for my learned friend to say, well, yes, but we didn't want to do that, we wanted mandatory relief. If there were a case where it were so urgent that it was necessary to come to the High Court, then it may be that an interim order for mandatory relief could be made if the case warranted it, as my lord has said. But in my submission, and this is the second, that would not justify or did not justify in the present case the continued pursuit of a final mandatory order in place of the statutory scheme. By that stage, by the time His Honour Judge Rawlings entertained the application for a final order, there was an interim order in place. There were enforcement proceedings on foot to maintain that order. The final mandatory order, in practical terms, achieved nothing additional to the interim order that had already been made, in which it was said the authority were in breach of. The contempt proceedings might have added something if a judge had said, yes, you are in breach and I'm going to take coercive action in order to insist that you do comply with that. That would in many ways have been a more, not appropriate, but a way of enforcing the order they already had, while at the same time there could then be proper consideration of the question: has the duty been discharged? Has the suitability of the accommodation been properly challenged by way of the statutory scheme? But otherwise, it simply amounts to a bypass. Any properly represented applicant who knows that the order, the obligatory duty is to provide suitable accommodation, and who wishes to challenge suitability, simply come to the High Court and ask for a mandatory order, thereby allowing them to say, well, the statutory remedy isn't adequate because I need relief the county court can't give. That can't be.
Mr. Nabby placed some emphasis on the fact that in this case, the High Court granted an interim mandatory order,
Yes.
and that was not appealed.
No.
Is there any significance on your submission?
No.
Why not?
Well, because what we are appealing in this case is the decision of His Honour Judge Rawlings. I accept that the interim order wasn't appealed. Just because an interim order was appealed doesn't mean that a final order inevitably follows as night follows day, or that the issues in relation to the findings that Judge Rawlings made are untenable. It's noted that at paragraph 59, I think, of Judge Rawlings' judgment, he makes the point that Judge Williams, granting interim relief, wasn't making findings of fact. He was simply assessing whether there was a serious tribal issue. And that therefore, in my submission, the exercise that the judge at the final hearing was undertaking was a very different one. That doesn't mean that he was entitled to make his own findings of fact, as I've already said. What it does mean is that the fact that interim relief was granted, as it may often be granted, doesn't mean that mandatory relief on a final basis must follow as night follows day, or even would normally follow. It's a matter that has to be decided afresh on the basis of the way the case proceeds in front of the judge hearing the final order. By that time, a review of the decision of the 4th of June that the accommodation, if I'm right, was not unsuitable, could have been asked for and probably completed, even if an appeal couldn't have been. And it's not the appellant's submission that Judge Rawlings was obliged either to grant mandatory relief or simply throw the claim out. The final order application could have been adjourned, pending a decision of the authority on review as to whether it wished to argue that the accommodation was suitable, or pending an appeal to the High Court, to the County Court. So, my Lord, my submission is that none of that really makes any real difference. I'm not suggesting there could never be a case where the circumstances were such that interim relief was needed, or even where the circumstances were such that a final order was needed. But in my submission, none of the matters relied on by my learned friend are exceptional in any sense, and none of them provide that the alternative remedy we say should have been adopted was inadequate or in any other way.
Right.
My Lord, just if I can pick up a couple of points. Paragraph 45 of the detailed grounds, clear that the authority is not accepting that the accommodation provided or offered at that date was unsuitable. I accept that it makes reference to more than one set of accommodation, but it's not a case where it was clear that the authority was saying we haven't complied with our duty until the last moment. Because paragraph 45 makes it clear that the authority was saying that the accommodation offered or provided. In the same way, I can't read that one. I'll move on. Can I finally just address you briefly on the construction point? The question of Section 1936D and the construction we give it, we say, does not lead to absurdity. My learned friend made a number of points, if I can just take them very briefly in response. First of all, under Section 1936A, the duty ceases where a person ceases to be eligible for assistance. So that's a basis for duty ceasing, regardless of performance of the duty by the local authority. It doesn't follow that accommodation needed to have been provided or needed to have been suited.
To do with immigration status.
Yes, yes, to do. Well, the only point, the reason I raise it is because it's not that all of these subsection 6 circumstances depend on suitability of accommodation. B, I addressed you on homeless intentionally. You heard about the, my own friend took you to a passage in the best case, made it clear that to be intentionally homeless under B, the accommodation would have to be suitable.
No, we're not bound by best,
No.
but you don't contend that it's wrong.
My Lord, under C, my learned friend said, well, our argument on that was wrong and indeed led to an absurdity, I think, because you could challenge the suitability of an offer under Part 6. But that was not the point we were seeking to make. The point we were seeking to make was, if the local authority makes a perfectly suitable and acceptable and reasonable offer of other accommodation under Part 6, my learned friend's argument were right, unless the temporary accommodation the person were already in before that offer of permanent accommodation was made, unless the temporary accommodation was also suitable, then arguably it wouldn't matter that the final offer under Part 6 was acceptable, because the authority could not cease to be subject to the duty, having not performed its Section 1932 duty lawfully. So what we're trying to say is that there are a number of situations in subsection Section 193(6) where the lawful performance of the Section 1932 duty is not a prerequisite of the cessation of that duty. And therefore there's no reason why as a matter of construction, the situation specified in subsection 6D must inevitably and automatically relate to suitable accommodation. My Lord Justice Phillips raised the question of subsection 5A and whether the introduction of the word suitable before the word accommodation there would make sense. And in my respectful submission, my Lord's question was correct in that it the reply my learned friend gave, which was, well, if it wasn't suitable, then there would be a problem in terms of seeking a review, I think was his point, because there would not be a requirement that the accommodation had to have been suitable. But that's misconceived in my submission. What subsection 5A is dealing with is a situation about information that's given, and then about the refusal of an offer which the authority has satisfied is suitable. Now that doesn't stop the applicant seeking a review under section 202 of the authority's satisfaction that it's suitable. And if the authority is wrong, in the view of the court, the court will quash the decision of the authority that it was suitable, that it was satisfied that it was suitable. So it doesn't take it any further, adding the word suitable before the word accommodation. What I meant to say was that in relation to the adequacy of the alternative remedy, there was another point I meant to make which I didn't, which is that the county court can of course vary the authority's decision as to suitability, which the High Court can't, or very rarely would be able to. So in fact, there is an additional benefit to an appeal in the county court, because if the county court judge thinks the decision is very badly wrong, the county court can simply vary it to a decision that the property is unsuitable. And that might give rise to a valid application to the High Court. But coming back to the construction point, it is certainly not disputed by the defendant that section 206 requires accommodation to be suitable. It's important, we say, to distinguish the two senses in which section 193 operates in terms of offers and discharge and cessation of duty. Discharge in this statute is often used in two senses, one to mean performance of the duty, and the other to mean to bring the duty to an end. There is no reason why, as a matter of statutory construction, the requirement to perform the duty by offering suitable accommodation means that it is inevitable that the duty can only be brought to an end if that has happened and as I've submitted. There are other situations in section 1936 where that is not required. But we say it's not absurd at all that on our case, cessation of duty under section 1936D does not prevent the applicant from reapplying. We say that is absolutely right. It doesn't prevent the applicant from reapplying. What it does is provides a lower tier of remedy, if I can put it that way, than section 1936B. Section 1936B, if you can show that they were intentionally homeless, then you don't have to consider a fresh application. Section 1936D simply solves an immediate problem where someone has voluntarily gone away and you can discharge the duty. Perhaps a more common and garden example than I gave this morning was where somebody just disappears. And then section 1936D gives you the right to say, well, you vacated it, so the duties come to an end. If they come back, yes, of course, they can reapply. And it doesn't prevent them from having the benefit of a further duty if they satisfy the criteria. But just as if someone who goes, somewhat regret using this example, to Manchester because they're fed up with Birmingham, can't be the recipient of a section 206(1)(c) duty from a learned friend certificate for two reasons. One is because advice and assistance given under section 206(1)(c) has to be such advice and assistance as will secure that accommodation is available. And it wouldn't be the advice and assistance who would be securing that accommodation. The person on this analysis had already, on this hypothesis, had already gone off and got accommodation. But giving advice and assistance at that stage wouldn't comply with 206(1)(c). And nor would the authority be in a position to satisfy itself that the accommodation required by the individual by themselves was suitable, which is the other requirement of section 2061C. So 2061C does not provide a way out. What we're saying, if my learned friend is right, then even in a case where the applicant has simply disappeared, as a matter of law, the authority could not discharge the duty unless it had provided suitable accommodation or secured suitable. My learned friend may be right that if you sent out a letter saying the duty has ceased and no one came back to you and said, well, I disagree, then you've got away with it. But that's not a construction point, that's just a practical point. A matter of construction, on my learned friend's analysis.
Manning, I am going to have to ask you to draw to a close.
My lord, I think I have just about... Could I make two one-sentence comments?
Yes,
on
literally one sentence.
two cases that my learned
If you
friend
don't make them
referred
in
to?
2 sentences, I'll just stop.
I'm grateful. Griffiths was a case about section 1935, and the only reason the court was considering 1936 and 1937 was because the argument in the case was about whether the authority had wrongly used 1935 when it should have used one of those other subsections, so that although Lord Justice May referred to the passage that my learned friend referred to, that the accommodation was suitable under D, that was not a matter that he was actually being asked to consider, and that, as I understand it,
That's Griffiths.
there was no full argument.
Yes?
Robinson
Yes.
was an extremely obvious case of an authority deliberately acting in such a way as to frustrate the purpose of the Act by telling someone they had to go away, knowing that the effect of them going away would be that they would then be entitled to a later date to make a refusal. Completely different from the facts of this case, where there is no taking advantage of a wrong. There is only a situation in which either the Act says you can or doesn't say that you can discharge a duty, and we say as a matter of construction it does.
Right.
My Lord, I think those are my 2 sentences.
Thank you very much.
My Lord, I do apologise, I have no right to stand up. But in response to El Kundi, which my learned friend raised for the first time, I'm just going to refer you to paragraph 299. It's tab 12, paragraph 299, page 196, which sets out why, in that case, the court declined the invitation to review suitability. And there are 4 reasons given there. I say no more than that. Secondly, relevantly, this claim for judicial review was issued for any offer of accommodation is made, and was issued to obtain accommodation.
Right. Well, that really is the end of this hearing.
Thank you.
I'm grateful to everyone concerned, not only the advocates we've heard from others who have prepared this case. We will reserve our judgments, and draft judgments will be circulated to the legal representatives. I haven't myself seen a list. I hope one has been sent.
The list was provided
All right.
to... I'm afraid I don't know which of you...
That's fine.
Oh.
I will proceed on the basis that there is a list of authorised legal representatives, and only those people will be sent the draft confidential judgment. And that's only for the limited purposes of correcting obvious factual errors and typos. It's not for re-arguing the case or for any other purpose. And I must emphasise, as this court has frequently done over the last few years, that any breach of the embargo of the confidential draft judgments is taken extremely seriously by this court. Thank you very much.
What rise the table?